All that said, let's get started. I am pleased to introduce to you WSHU's General Manager, Rima Dial.
Hello, good evening, friends. I'm Rima Dial, General Manager for WSHU Public Radio, and we're located on the campus of Sacred Heart University in Fairfield, Connecticut. Welcome this evening to WSHU's popular lecture series, Join the Conversation, where we feature fascinating and a wonderfully diverse group of voices on current events in our community and across the nation. Thank you very much to tonight's sponsors, Petrosky, Reisenman, and Myers PC. Thank you very much to all of our WSHU listeners, donors, and sustainers. Tonight's focus is on the First Amendment. The First Amendment, what it is and what it isn't. And now it is my pleasure to introduce our award-winning senior political reporter, Ebong Udoma. Good evening, Ebong.
Good evening. Thank you so much, Rima. And good evening to everyone. The First Amendment, what it is and what it isn't, that's tonight's Join the Conversation. And I'd like to start by introducing you to our panel. Nadine Strawson is the former president of the ACLU, a constitutional law expert, and the author of Hate, Why We Should Resist It with Free Speech, Not Censorship. David Falkenflik is NPR's media correspondent. He's a 5-time winner of the Arthur Rouse Award for Press Criticism from the National Press Club and the author of Murdoch's World, The Last of the Old Media Empires. And William Tong is the 25th Attorney General to serve Connecticut since the office was established in 1897. He took office in 2019 as the first Asian American elected to statewide office in Connecticut. And I'd like to welcome you all. How are you doing this evening?
Great.
Let's get right into it. Let's start from what happened on January 6th. Based on your understanding of the First Amendment, what it is and what it isn't, was Twitter right to ban Trump? Let's start with you, Nadine.
Twitter absolutely had a right under the First Amendment to ban Trump because the First Amendment only binds and limits government. If you are a private sector entity, such as a traditional media company or a social media company, not only do you not have a First Amendment obligation to respect other people's free speech rights, moreover, you have your own First Amendment free speech rights to make your own editorial judgments about which speakers and ideas you will host and which you will not host. Now, I happen to think that Twitter did not make the correct decision from a policy point of view, but it certainly had the constitutional right to make the decision it did.
Okay, how about you, David?
I think this is a tough call. What you're hearing from Nadine is both the recognition of Twitter as a private actor to its own First Amendment rights to decide what it publishes and not publishes, and the question of sort of the penumbra of the First Amendment. You have these enormous platforms that amplify people's speech and can also muffle or muzzle it, and they play an incredibly important role. You know, if you're thinking of Facebook as, in a sense, a platform through which people communicate, like Verizon or AT&T, you would not want them to have the right to say Trump can't make telephone calls because he says something that you disagree with, or even conference calls, simply on the basis of his remarks, unless one felt that what he was doing was actually explicitly inciting violence. On the other hand, if you think of him as a publisher, as many people now do, and as even Facebook and Twitter officials at times concede, that they are effectively serving as the role of a publisher, more like a broadcaster, like an NPR station or like CBS or like the New York Times, then they do have editorial discretion about what they do. And Trump certainly had been in the business of amplifying claims that were harmful to our understanding of COVID and the evolving scientific and public health understanding there, and also our understanding of the election and what he thought was appropriate in response to that. And I think certainly there's a strong case to be made that he helped propel not only the protests, but the fury that we saw evinced in the actual siege of the Capitol. And I think that, a permanent ban is a long time, but one can understand why there's trepidation about allowing him access to such an amplification, such a megaphone, if you will.
Ebong, at some point, I explained my policy objections to what Twitter did.
Yes, after we get Attorney General Tong on, let's get his opinion, and then we'll come right back to you. I'd made a note of that, so please, Attorney General Tong.
Well, thank you, WSHU and Ebong, for hosting us tonight, and I hope that everybody listening and watching is safe and healthy, and your families are as well. Let me just say, first of all, I think Nadine hit it right on the head. I don't think there's any question that Twitter had the legal right to do what it did. And I think Twitter got it right from a policy perspective. The reason why I think that, though, is because the question of whether Twitter had the right or whether what Twitter did was the right thing to do is only one half of the question. The other question focuses on the speaker. Right. And we have to analyze what Donald Trump said, and he did, and Josh Hawley and Ted Cruz and a number of other people in inciting in what I view was an incitement of violence and encouraging people to storm the Capitol and to attack the seat of democracy. No matter who you are, you do not have a First Amendment right. Number one, this is a myth that we all buy into, that you have a First Amendment right to say whatever the heck you want at any time, in any circumstance. That's just not true, right? The classic example is you don't have the right to shout fire in a crowded theater, and you don't have the right to incite violence. It doesn't matter who you are. And that's the second myth, which is just because he's the President of the United States or Josh Hawley is United States Senator and they're elected officials, and I guess they're ostensibly engaging in political speech, that they can also do whatever they want in that context and that they're not accountable. I think that's also false and a myth. If you actively encourage people to commit violence or to hurt other people, that's not constitutionally protected speech. I don't care who you are. And that's what I think Twitter was responding to, which is why I think Twitter got it right.
But Nadine, you have some reservations. I know you're a big proponent for the answer to hate speech is more speech. Now, is that part of why you have concerns about this?
Actually, first of all, let me say where I do agree with William, and I hope we can be on a first name basis since it's not the first time we shared the quote together, but otherwise general. I, of course, agree that the First Amendment does not protect intentional incitement of imminent violence that is likely to result in imminent violence or lawlessness. And in fact, there's a lot of debate going on right now among constitutional law professors and other First Amendment geeks about whether Trump's speech, both on January 6th and leading up to it, would satisfy that appropriately demanding standard. But putting that aside, Ebong, the biggest concern I have about social media really goes to a point that David was making, which is these private sector entities not only are not subject to constitutional constraints under the First Amendment, they're not subject to any constitutional constraints at all. Not due process, not notice, not accountability, not transparency. And in that sense, I think that Jack Dorsey has more power and is more frightening and endangering of liberty and democracy and equality than Donald Trump. Donald Trump could be impeached. Jack Dorsey cannot. Donald Trump could be diselected. Jack Dorsey could not. And I think it's no coincidence that we had political dissidents around the world, including Alexei Navalny, objecting to Twitter's deplatforming of Trump, because this is a power that, of course, is going to be disproportionately used against dissidents. And in this country, the ACLU issued a statement saying, look, Donald Trump can get access to other platforms, but traditionally marginalized and disempowered minority groups are going to be the ones that will not have alternative platforms. This is very dangerous power.
So the decision maker is the issue here. And that came about because of Section 230 of the 1996 Communications Decency Act. Is that true, David? That's where these media, that's where the social media firms hang their hat on Section 230 of the 1996 Communications Decency Act.
Sure. Well, General Tong may have this a little bit more precise than I do, so I'm going to defer to him. 30 seconds. But what I would say is the shorthand version of it, as I understand it, is that basically Section 230 of this code allows these folks not to be held responsible for, say, libelous claims or slanderous claims or the things that aren't illegal but could have culpability, as long as they're not acting as publishers, as long as they're acting in effect a little bit like platforms. It gets back to this tension of the role they're playing in the moment. If you think about light, the fact that we can look at light and study it variously as a wave and as a particle, you can look at Facebook and Twitter variously as platforms or as publishers, and the kinds of legal analyses that ensue depend on how you're looking at them. And therefore that determination is very important. If they are not acting as publishers, if they are not themselves exercising editorial discretion about what you say to your Aunt Millie by posting on Facebook on her page, then they're off the hook for the legal implications of it. If they are exercising discretion, which they actually do to a certain degree, then suddenly they are implicated a little bit in these things. So the more light touch they have, the better it is for them legally in terms of evading and sidestepping any legal culpability for what they do. It's actually a little more complex than that, and I'm going to turn to the Attorney General to fill us in on that. But in the common vernacular, that's kind of how it works. And you're right about citing the section that people invoke.
Okay, and AG. So, Attorney General Tong, what do you have to say? Because I have this feeling it's like having a common carrier like the phone lines, I guess, and saying, well, they don't regulate what goes on the phone lines. You can say whatever you want on your phone calls. They're not responsible for that. Is that kind of the analogy here?
Well, I think, frankly, there's a lot of focus on Section 230. That's sort of the controversy for our time and of the moment. But Section 230 is only one part of the equation, really, and only one consideration. Yes, it is from one perspective, a liability shield. From the other side, it is the reason why the internet grew so quickly and so strongly, and is such a at times a powerful force for good in the democratization of information, and at other times it is the information superhighway of hate and domestic terrorism. So there's a huge chasm there, between the two extremes of what Section 230 has produced. But I think as much as there's a debate about what Section 230 does and the limits of Section 230, the idea that private litigation or litigation by attorneys general, for example, on behalf of states, in court against tech companies, that is going to be an effective regulatory regime, I think is an open question, right? Will that really produce the results that we want? So that's why I think Section 230, for lack of a better description, isn't really a simple open and shut case. There are a lot of difficult issues there, but it's only part of it. The other part of it, and this is where I think Nadine and I, with respect, differ a little bit, and that's the question of whether Twitter and Facebook constitute the public square, right? Whether they provide a platform for speech that is so singular, right, in its reach, that it is essentially the public square, and that people should be allowed to engage in, a broad range of speech with not a ton of limits on it. And I just don't agree that Twitter, for example, it may be part of a larger universe of spaces for us to speak. But at the end of the day, just because Donald Trump doesn't have Twitter doesn't mean he doesn't have a megaphone. He does. He's the former president of the United States, and people hang on his every word. Actually, about half the country, 69 million people. And there's no problem with Donald Trump going down to Washington, D.C., standing outside to the extent that he can, and screaming at the top of his lungs whatever he wants to say, so long as it doesn't get anybody hurt. So I think the public square is still there, even if Twitter enforces its terms and conditions, which is why I think Twitter made the right call to try to stop Donald Trump and others from fomenting dissent and insurrection.
Well, again, William, my concern is not, as I said, with Donald Trump, but it's with all the other speakers over whom Twitter has such unbridled power. And I'm so glad that you talked about the positive value of Section 230, because we tend to overlook all of these, to me, wonderful movements that really could not have gotten off the ground were it not for social media, including the Black Lives Matter movement, the Me Too movement, many young candidates, inexperienced candidates without access to money, women, minorities, young people. It really has lived up to the promise that Section 230 was designed to unleash, namely disincentivizing the platforms from being strict gatekeepers, literally making it possible for the first time in human history for every single one of us to communicate with every single other one of us. And in my ideal world, there would be a multiplicity of platforms that would have different policies and different standards for what speech would be allowed and not. And we would have user empowerment, user freedom of choice. I think that's what Section 230 envisioned. In fact, its name in Congress was the User Empowerment Act. What was not foreseen was the rise of these dominant platforms. And as I understand it, William, attorneys general are bringing lawsuits on antitrust grounds, arguing that there has been too much power concentrated in a few dominant platforms.
That's the general theme right now, that social media should be brought under some type of control. Is that what's your argument when you're going up against social media firms, Attorney General?
Well, the antitrust question, though related, is different from the free speech question. They're intertwined. But the antitrust question really is about market power and consumers, and using the power, their market power, to prejudice not just consumers, but their competitors. And that's a different question from trying to help the social media platforms enforce terms and conditions that limit the amount of hurtful, dangerous, or damaging speech that goes through their platforms. So yes, we're trying to hold social media companies and big technology companies accountable under the antitrust laws when they violate them by using their market power to prejudice others and consumers. And that's something that frankly the antitrust laws were written to guard against. And it goes back to the trust busting and the ways in which we, for a long time, have used the antitrust laws to create a more fair and open marketplace.
One of the connections between Section 230 and the antitrust concerns is that it would be so expensive it would be a real barrier to entry to new companies if Section 230's liability shield were removed, right? Many people say skeptically, that's why Mark Zuckerberg is cheering for Section 230 to be repealed, because Facebook could contend with it. But it would be harder for us to have more choices in terms of new companies on which to exercise our free speech.
Well, let me say that.
Before we go into that, let's get David into this.
Okay.
Just for a minute here. If we do break up these large social media firms, do you see a situation where there would be more speech, because basically what's happening here is the Attorney General would like to see to use antitrust to go after them and to try and break up the large social media firms. If that were to happen, what do you think would be the what do you think would be the outcome of that? Would it actually free up space for more voices?
It could. It's interesting to think about Microsoft, which a generation ago was broken up and still remains quietly one of the best investments and one of the biggest, Fortune 50 companies in the world, probably a lot closer to the top level than that. One of the major, half dozen tech companies in the world. And that was after having been broken up in a sense, been forced to be cleaved in two. The real target in some ways for this is less Twitter, although there's some questions about Twitter as well. But, begging the apology of these people to my left and right who are so steeped in this stuff. But if you think about it, really Facebook, which by taking over, people are focusing on Oculus and virtual reality, but what really seems to be the case is more of WhatsApp and Instagram. These are two huge other platforms, very different in nature, very different in the kinds of expression that occurs, but nonetheless used by people with family and friends, used for business, to some degree marketing or communication, used by, particularly in the case of WhatsApp, which has secure communications grounds, oftentimes by whistleblowers or democracy advocates in other areas, much like Signal is just desperately valued by people trying to communicate securely. Facebook is a place that essentially vacuums up personal data in such a way that the ability to express yourself freely and perhaps anonymously in ways that aren't discernible to authorities, particularly in, not just law enforcement authorities in this country, although such things were used and shown to be used by law enforcement on January 6th, rioters, among others, but particularly abroad, where in Iran, if you walk in the country, you're supposed to turn in your phone and then they go through all your social media accounts to see who you're talking to privately and who you're not. Yes. These things being broken up might allow certain kinds of norms and certain kinds of security to be maintained with more confidence by the public. And I think there are implications there as well as the explicit ideas of free speech. But, to be honest, in this moment, I think there's a strong case to be made for breaking up something like Facebook. I'm not the legal expert. The judges will ultimately decide these things, but I think there's at least a strong legal argument to be made for it. I'm sure for places like Twitter as well. And yet I think a lot of the ability for others to flourish will be in the technology itself. And whether a TikTok emerges, perhaps, not owned with an investment from Chinese authorities, but nonetheless emerges and is allowed to be maintained independently and not sort of subsumed into one of the new tech giants, and new ones come on board. And that is the way these things are going to happen, where people actually see technology that benefits them. Facebook seems absolutely unassailable, but not everything it tries sticks. And we forget that. A lot of the technology, the reason that they've become so big is they've bought what should be, in a sense, their competitors. And I think that we need to see these competitors arise and also certain kinds of acquisitions blocked if one is really concerned about the accretion of corporate influence and power.
So basically what we're talking about here is allowing private companies to operate in a public space, and whether that how that affects the public space. Is that
exactly what we're talking about? I mean, CBS does this, although it's regulated. The New York Times does this and effectively isn't, except to the extent in which people can take them to court, whether they're government or independent individuals, and try to hold them accountable for what they've done. But the fact that these are private actors, that's set up and inherently intended by our system, right? We want people to have freedom of speech individually, and we want corporate actors to have freedom to make their own decisions within the law. And now we're just deciding how those laws should apply. I'm sorry, please.
Yeah.
Go ahead, and then I have a quick question.
Well, yeah, let me just say, and to follow up on what David said, I think many of us have often said, if there was no Microsoft antitrust enforcement action, there would be no Google and there would be no Facebook. And there's probably a lot of truth in that. But I think what's really interesting, and I think Nadine and I were going down this road, the central thread between the antitrust question and the free speech question is this idea of competition, right? So we have antitrust laws because we think that a particular marketplace in a particular instance is broken, isn't functioning efficiently, and there isn't real competition. At the same time, the people that would argue against antitrust law enforcement would say, no, that's wrong. Just let us compete. And whatever happens in the market happens, right? And that is, Milton Friedman, that'll produce the most efficient result. So if Facebook gets bigger and bigger and bigger because it's a better, more efficient actor, then let it do its thing. And the consequences will be what they are. Well, it's interesting because we say as a country, no, that's not okay, right? We think that companies like Facebook and Google, and a generation ago, Microsoft, abused their power, right, to stifle competition. And so the government has to step in and regulate otherwise permissible and lawful activity. Well, now let's go to this free speech side. I think what Nadine is saying is let them compete. Let the ideas flourish on Twitter, and let's have a competition of speech. I would argue, except when that platform requires regulation of some kind. It needs a referee because somebody like Donald Trump is so dominant that they're creating a lot of damage to their speech. So that speech competition isn't working.
Talking about a referee, what's the line that defines hate speech as opposed to a strongly expressed opinion?
There is no legal line, Yvonne, neither in the United States or under international human rights law is there a single definition of hate speech that is not legally protected. It's slightly different under international, so let me stick with the United States. The U.S. Supreme Court has never recognized a category of speech defined by its content, its message, its viewpoint that is hateful, and said, therefore, it's not protected. So it's very different from obscenity, which is a specific category of sexually explicit speech, where the Supreme Court has said, if speech satisfies our definition, then it is completely excluded from constitutional protection. With respect to hateful speech, the Supreme Court has over and over and over again said, just because its ideas are hateful and hated is not a justification for suppressing it. You have to answer back. You have to fight against actual discrimination. You have to fight against actual discriminatory violence, but you may not silence the speaker solely because of the hated or hateful message. However, if you get beyond the message and you look at the overall context and circumstances, then the Supreme Court has said if the speech, if it's hateful or conveys any other message, if it directly causes or threatens certain specific serious imminent harms, then it can and should be punished. And the Supreme Court has recognized a number of examples of subcategories of speech that satisfies that what's usually called an emergency principle. William and I were talking earlier about one of them, intentional incitement of imminent violence or lawlessness that's likely to happen imminently. If that's the context in which the hateful message occurs, then it can be punished. Or another example is a true threat. If the speaker is addressing a small audience or a single individual and means to instill a reasonable fear that they are going to be subject to attack, that can and should be punished. And another example is, targeted harassment or bullying. Sadly, there are many examples of hateful messages that occur in those contexts, both online and offline, and have been subject to punishment. And if I can mention one other concept, which has been enforced in Connecticut fairly recently, is the so-called hate crime. That is a legally recognized concept. If somebody commits an assault or vandalism or some other crime that's independently punishable, that irrespective of the idea or the expression of the person who commits the crime, and if the crime victim is intentionally singled out because of a discriminatory motive, To use the example from Meriden, Connecticut from a few years ago, a mosque is shot at because of discrimination against Muslims. That can and should be considered to be a more serious crime, usually referred to as a hate crime or a bias crime, and can be punished more severely, but not the speech alone.
Is some action protected by the First Amendment? Is there any action that is protected by the First Amendment?
Yes, a lot of
ton.
burning a flag, marching.
Could Attorney General Ton come in first, and then we'll have David weigh in on this as well.
Sure. I mean, the First Amendment is extraordinarily broad, and I think it would be a mistake to think that that we have limited it so much that it is not still strong and vital and broad, and people have the right to say a great many things. They don't have the right, and they have the right to say a great many odious and hateful and wrong things. What they don't have the right to do, and have never had the constitutional right to do, is to hurt somebody, period, or to endanger somebody's life, or to commit an assault, whether by your words or by your physical battery. And that's where hate crimes enforcement comes in, that if you, by your words, put somebody at imminent risk of harm, put them in danger, or cause them injury or death, and under Connecticut law, if you intimidate them in those circumstances because of a discriminatory purpose, you can be held criminally liable in Connecticut for committing a hate crime. And after that incident at the mosque, I think it happened in 2016 and 17, around there. Frankly, after Donald Trump was elected, there was a 20% spike in hate crimes across the country. Connecticut was, not accepted from that. It was the attack on the mosque. It was attacks on synagogues in Woodbridge and West Hartford, swastikas being painted in Danbury. And as a state legislator and chairman of the Judiciary Committee, I rewrote and strengthened our state's hate crimes laws. And every time you do that, we have to revisit the constitutional underpinnings. And there's just no doubt that the state has a compelling state interest, to borrow a constitutional concept, to come in and protect people from imminent harm as defined in our statutes.
David, do you have anything to say about this?
I mean, you see it, of course, in the exercise of journalism, and you see it in the things that we cover at times. I was an intern, 31 years ago in Charleston, South Carolina, and one of my assignments was to cover a Klan march through the streets of, I think it was Monk's Corner outside Charleston, and then through Charleston itself. Their legal rights to assemble and to protest peacefully, which they did, was protected by a police chief who was Black and Jewish in Charleston. And he saw to it that, he both addressed the press before and after, and he addressed his police about what he expected. And he was, protecting them from the much larger counter demonstration, which was also legal and also protected. It gave me a firsthand introduction to the kinds of protections. I had a college professor who once said, attending a sporting event, he said, "Your right to wave your fist out in cheering or denigrating the other team ends right before it strikes my face." He said, you can be vigorous, but you can't be violent. And you can say things that offend me, and that has to be okay. But there are these nuances that where lawmakers and lawyers and judges are drawn in about where something goes from reiterative, objectionable speech to harassment, where something goes from being biased to being a hate crime. Scrawling epithets on a wall allows people to say, this is a defacement of property that doesn't belong to you. We can invoke the idea that that is a property crime and implicate that into getting it to a hate crime in a way where if you say something spiteful and hateful and an epithet, that's probably not prosecutable unless it's attached to some other action. And again, these two fine people know this in better terms than I do, but these are the kinds of things you watch. Among the things I do for NPR, I cover journalism, I cover media more broadly. So I think about these things, but I also cover rhetoric in certain ways. and the ways in which we process language and figure it out. And language isn't action, but it's not action at times. And therefore, it does affect what people do and how they feel and the security they feel, the pride, the shame, and the perhaps inducement or encouragement to do terrible things. And these are the balances we go through. The First Amendment that we're talking about today gives us the right to free speech. It gives us the right to assemble. It gives us the right to observe religion in manner that may be an affront to others, but feels right to us. And that has to be okay. But it is not absolute. There was this guy I covered in my early years named Stanley Fish, who's a law professor and literature professor, who wrote a book intentionally provocatively titled "There's No Such Thing as Free Speech and It's a Good Thing Too." And, he said child pornography is not free. You're not entitled to traffic in that. You're not entitled to go to a crowded theater and shout fire. There are all kinds of exceptions embedded into the law as it's interpreted by senior court officials in ways that restrict it. So we have to, and of course, national security concerns about what you can say if you're a whistleblower, what processes you're supposed to go through versus the processes that people sometimes do, what you're allowed to say publicly. We don't have an Official Secrets Act, and yet there are all kinds of secrets that the government is intent on keeping from us, whether run by either party. And so these are freedoms that have to be consistently thought through and consistently fought for by people of good faith and figured out. And so it's hard to write it, on a Post-it and say we've got it solved and we've got it defined, because it's going to keep getting challenged and it's going to keep evolving.
Talking about it being challenged, was the insurrection at the U.S. Capitol on January 6th, was that protected First Amendment activity? Nadine?
Well, you have to break it down. If you're talking about the insurrection itself, people committing at the very least trespass, at the very worst assault, and possibly homicide, certainly that's not protected, even if the reasons for the violent illegal conduct was because people were trying to convey an idea. That is not a justification or a defense for actions that are clearly independently illegal.
Where did they cross the line?
Well, they crossed the line, first of all, in committing trespass, secondly, in assault and battery, third, in conspiracy. So now I'm getting away from actions. Where it becomes more complicated is where words only are involved. And here I think if the words are, including in social media and other communications, for purposes of planning to carry out a violent attack or to commit illegal acts, including storming the Capitol, conspiracy charge is completely appropriate. And I've defended that. The ACLU, famously or infamously, depending on your perspective, defended the free speech and free association rights of the Unite the Right demonstrators in Charlottesville in 2017. And the judge agreed with us because at that point there was no evidence of plans to engage in violence, and the police testified that they would be able to protect against any potential violence. However, subsequent investigation brought to light that there were a lot of plans beforehand, similar to what we see now with respect to January 6th, to bring weapons, to assemble, to commit violent acts. And that conspiracy charge, I agree with the judge in Charlottesville who already rejected a First Amendment defense. And I would reject a First Amendment defense to similar conspiracy charges arising out of January 6th. Now, where it gets really hard, Abang, there's a case going on in New York right now, which I understand is a test case in federal court of a prosecution against somebody only for social media posts supporting the insurrection. He did not participate in it himself. William, I've looked at the language. I don't think it meets the test of intentional incitement of imminent violence or threats. And I think there may well be a successful First Amendment defense, but he said very ugly, incendiary things, and racist statements. And but that will be an interesting test case of whether some somebody who only engaged in expression, not any planning and not any carrying out of actions, will be subject to prosecution.
Now, before we go on, I'd just like to remind the audience that you can submit questions by clicking the question mark, and for those on mobile devices, you can click the hand, and you can get your question in. So let's go now to David. What do you think, from my question about January 6th and what happened at the Capitol, where did that cross the line as far as you're concerned, if it did?
Oh, I mean, I don't think there's any question that illegal acts were committed in terms of storming the Capitol on January 6th. I think it's telling that Nadine Strossen referred to the Charlottesville, call it a march, racist, anti-Semitic protest, this angry, it's an expression of white power one way or another. And the reason is because of the rhetoric that was unleashed as people were seeking to essentially storm the Capitol, figuring out windows to break down, doors to enter, fighting back against cops who were not, by any visual evidence we saw, behaving in a provocative or particularly confrontational way at all. People calling out to find Pence, people had, there had been a gallows hung at the foot of the Capitol lawn, and people calling for Pence to find him, to hang him, because he wanted to certify the result in favor of Biden, even if that's overheated in the moment, whatever. I don't care. It's the Vice President of the United States. They're marching inside the halls of Congress. I covered Congress for 3 years. This is a terrible assault on one of the seats of government. It is as important an edifice and institution as the White House. And, there is no doubt that was illegal. And there is no doubt that those that encouraged the continued sharpening, the continued elevating, the continued fueling and propelling of the anger behind that rhetoric were playing with fire. And that it ultimately, it led to what we saw. It gave a free pass, and it gave essentially a thumbs up to what we saw. I don't know if that constitutes something criminal. I do know the actions that were occurred were clearly criminal acts and are clearly enforceable. If you think that, when there were, back in the day, when there were old anti-WTO protests and people would crack the window at Starbucks, those were prosecutable events, whether or not you just chose to prosecute it or to kind of treat it non-criminally in a way of defusing tensions with protesters. These are clearly criminal acts.
Okay, now, Attorney General Tong, anything to add to that?
Yeah, I think Nadine talked about the social media case. I think it's important to focus on the speech, and it's also important, as I said earlier, to focus on the speaker. And the context makes all the difference. And so I think we all agree that storming the Capitol, hurting people, breaking windows, stealing property, all of that rightfully is not constitutionally protected conduct, and you can be prosecuted, and those are criminal acts. The bigger question, of course, is whether what Donald Trump said hours before it happened and during the attack, or whether what Josh Hawley said or did, or Ted Cruz said or did, is wrongful and constitutionally protected. I'm very cautious about this because I know that political speech is the core of the First Amendment. What does that mean? That means when we talk about the First Amendment, political speech is at the top of the list. That's the point of the First Amendment. However, okay, as I said earlier, I don't care who you are, you don't have the right to use your platform to incite other people to commit violence or to hurt people, number one. But number two, you also don't have any right to commit treason, period. And I don't care who you are and what office you're elected to. If you are using your position and your speech to incite an insurrection, seditious action to overthrow the democratically elected government of the United States of America, you don't have a constitutional right to do that. And I would argue that's what Josh Hawley was trying to do. And that's what President Trump in that moment was encouraging people to do.
If I might interrupt you, Bong. So,
Okay, quickly, and then we'll get to a question from the audience. But
very quickly, and I apologize for stepping on your role, but I want to ask, so do you see that as a political crime, as in something addressed by impeachment or addressed by the Senate, as was handled by the House against Trump, or do you see that as something actually prosecutable by some of your peers in law enforcement?
I see it as both. And this is a really important point. We've thrown out these constitutional and Supreme Court buzz phrases like fire in a crowded theater, and another one that we talk about is we live under a set of ordered liberties. The other one that we frequently cite among Constitution nerds is the Constitution is not a suicide pact, right? We don't protect our liberties to such, in absolutist terms, to such an extent that you produce absurd results that put people in danger.
But can I point out the opposite extreme? And I appreciate, William, that you said we have to proceed cautiously because it's political speech. But when you talked about sedition and treason, I thought of Eugene Debs, a serious presidential candidate, right? The head of the Socialist Party, who got a 10-year prison sentence for simply criticizing war policy, for suggesting to people that they had better purposes than to be cannon fodder, and he was trailed by the FBI and he was prosecuted. So we want to be sure that that it is intentional incitement of imminent violence. It's a strong test.
I totally agree with that, Nadine. But with all due respect to Eugene Debs, he's not, and it wasn't Donald Trump.
That's showing him a great deal of respect, I would say.
I guess that's true, but he didn't have the power that President Trump had in that moment to, in my view, push our country to the brink. And as your Attorney General, I looked into the abyss. I just want everyone, I'm going to deviate for a second. I hope everybody understands how close we came to the brink, okay? If one Republican-controlled state legislature had decided, you know what, we're going to listen to President Trump, and we're going to send a competing set of electors to the Electoral College, notwithstanding the popular vote. Let's call it Pennsylvania. What if Pennsylvania had done that and sent a competing set of electors to the Electoral College? All hell would have broken loose. And other states would have been emboldened and empowered to do the same. That's how close we came.
Okay, now let's get to a question from the audience. Bob Krellin says to thwart misinformation on so-called news media, should we demand a new FCC criterion to define media that can be called news? I guess the FCC should determine who's news and who's putting out news and who's not. And I'm just thinking about the situation with Fox that's being sued right now by Dominion for having people on their air who were calling the election into question. So can we start with David on that?
Well, so the question of who gets to define a journalist, one of the great joys of America is that there is no licensing agency you have to go to. You're not required to get a journalism degree. I didn't. You don't have to go in front of some august board at the state, like lawyers and dentists and barbers and hygienists for that matter. Like we don't have to be credentialed, which means that you could argue there are a lot of people in here who may not know the first thing about ethics or the history of media. But I think it's also part of our great experiment in democracy, in that it's not journalism is not simply the recording of events that play out in front of you. It also involves the perspectives and experiences and ideas and insights that people bring to it. And theoretically, they prove their value in the marketplace of ideas. You talk about Fox, and there's question about the extent to which they performed essentially a political role in the 2020 elections. I've done a lot of reporting on Fox over the years, and particularly in recent years. They certainly, by and large, threw their weight behind Trump, and in so doing, threw their weight behind a lot, amplifying and in effect validating a lot of conspiracy theories that were harmful to America's understanding of itself. But I think one of the real questions for the FCC is: should it be allowed to regulate to the extent it does the speech on the broadcast networks, as opposed to should we be extending it to cable? Why is it by the accident of the technological development that ABC and NBC are subject to strong, restrictions and fines through their local stations in particular that are now actually quite significant about obscenity, but also about certain kinds of political claims in ways that cable stations just can go off to the races, and effectively they are subject to the same questions of slander and defamation that a print newspaper is, but they're essentially scot-free. And I think there's it may allow us something useful in that there are different gradations of what our TV news is like, and maybe that's useful to have different strokes for different folks and different times of day. But I do think that constitutionally, it's just an accident of history. If Fox were doing Tucker Carlson and Lou Dobbs back when it was on through its broadcast network, it would have been a much more tightly regulated show than it sort of running freeform on cable. You can look at this from the other angle as well. Think of Julian Assange, the scourge of the Bush and the Obama administrations in particular, and the aid, as it turned out, and in a sense, counterintuitively to the Trump fortunes, by publishing a lot of raw stuff online. And they're being prosecuted now by the Justice Department. Assange is, WikiLeaks is, under the Espionage Act. And people say, look, this guy's an anarchist. He'll post anything. He won't even redact dates of birth, social security numbers, home addresses. He's putting lower level people, the Defense Department, CIA at risk. And I think there's a lot of truth to those concerns. But if you designate him as somebody who, by fact of publishing under the Espionage Act, somebody who can be prosecuted, smart people and not irrational people in major and serious-minded news outlets that take those very concerns very seriously about both national security and individual security and would not publish those specifics, they say, hey, we get dragged in under that as well. So the fact that the government is not defining journalists is probably a benefit, not just to journalists, because God knows we're self-absorbed, but to the public that benefit from the kinds of information we provide to in a public setting that can be evaluated, and that at times forces public officials to come back and say, maybe we need to reassess what we've done here. Maybe we need to think about extraordinary renditions. Maybe we need to think about drone attacks. Maybe we need to think about warrantless wiretapping. Maybe we need to think about a number of things that we do when it's not done in the light of day, that we do in the public's name at the public's expense, but couldn't hold up to public evaluation. And sometimes that happens from actors who don't wear suits and aren't pedigreed and don't work for the Washington Post and don't particularly care about journalistic norms. And that is not to defend everything they do, or in fact, to defend all of them or any of them, but it's to say these are the problems inherent with the idea of licensing. So when somebody says the FCC should regulate Fox, in a sense, viewers are going to have to regulate Fox, and Fox's owners are going to have to decide how they regulate Fox. And at the moment, they're deciding, they're proud of what they've done in terms of all the lies they propagated about the elections. They're proud of the seeming embrace of certain white supremacist tropes that Tucker Carlson has offered of late. And they're standing by what they're doing because they're desperate to hold on to the Trump voter. And remember, as a cable channel, Fox really wants 3+ million viewers in its prime time per hour, which is a little under 1% of the nation. It commands an extraordinarily powerful microphone while still getting a very modest niche of the public at any one time.
So for the lawyers on the panel, libel and slander laws are the way to regulate this? Is that how we control what goes out on the media?
If you're talking about disinformation or misinformation, that would be the closest analogy, because the truth is that our Constitution correctly protects most falsehoods. It's only in very specific situations, including defamation or fraud or perjury, where there is an intentional falsehood that causes some specific harm, that it can be punished. And as is well known to all of the journalists and probably everybody from at least watching this on TV shows and movies, you know that if the false and defamatory statement is about a public official or public figure, then it's still extremely hard to win a libel case. That public official or public figure has to show that the statement was not only a statement of fact, right, as opposed to opinion, that is verifiably false, but also that it was intentionally or recklessly false. And lately, there's just been a spate of defamation actions brought against everybody from, Fox News to MSNBC, Rachel Maddow, you name it. And most of those lawsuits are being dismissed on First Amendment grounds because the journalist is given a lot of latitude, including to make statements that are characterized by the courts as opinion or interpretation rather than false statements of fact. And for all of the damage that disinformation and defamation can do, Abong, I think the question we have to ask ourselves, and David gave a big part of the answer to it, is it even more harmful to empower government to be the controller of what is true and what is false, and what is opinion and what is fact? And, what all historical experts agree on is that the core purpose of the First Amendment from the very beginning was to prohibit the prior licensing schemes that had existed in Britain, where you could not publish anything without getting prior approval from the government. And above all else, that's what our forefathers and foremothers hated, because it did not enable any criticism of the government. It did not allow any dissent. And how can we, the people who wield sovereign power, and quoting the opening words of the Constitution, how can we do that unless we can have robust and vigorous free speech, in particular, to vigorously criticize, even wrongly and inaccurately sometimes, those we elect to be accountable to us?
Now, Barry C. asked, the First Amendment limits what Congress can and cannot do. Does the same apply for other state legislators?
Yeah. State action includes the states. Can I just say something though in response to the last question? And I don't have a good answer, which is why we're having this conversation. These are really difficult, thorny, fraught issues, and people much smarter than me have been wrestling with them for a very long time. I think my quarrel with Fox is, and with government control, is that we tried this before. We had something called the equal time rule. And it was supposed to give opposing candidates and viewpoints equal time on the airwaves. It really hasn't worked out. And the real trouble is that I think Fox has perpetrated a myth or deception. And the deception is that all viewpoints are entitled to equal weight. So from Fox's reckoning, right, fair and balanced means no matter what they say, they get 50% of the time. And everyone else gets 50% of the time. And that's just not true, right? Extreme views are extreme. And they should not be given 50% of the airtime, right, to basically infect the population. And I use that word purposefully so that people don't take the vaccine, right? It is patently false that we should give equal weight to vaccine deniers who are getting people sick and killed. And so that's the struggle. That's the challenge when we feature extreme views or views that are not supported by science. I'm not saying we can't discuss the efficacy of vaccines. I'm not saying that we shouldn't have a robust debate about them, but I am saying that falsehoods, intentional deception, misinformation, disinformation that puts people at risk and gets them killed, that's a real problem. So
let me just, I have another question from the audience which ties into this. It's basically on tolerance. How do you define tolerance? What is tolerance versus freedom of action?
Tolerance in the context of the First Amendment, which we've been talking about, is the concept that is usually referred to as viewpoint neutrality or content neutrality, that government must remain neutral with respect to the idea, the viewpoint that an individual or a group expresses, and may not favor or disfavor particular ideas. When we get beyond ideas and we talk about speech that has an actual direct adverse impact, including certain kinds of false speech, such as defamation and fraud and perjury, then the government may punish it. Does not have to tolerate speech that causes direct harm.
Yep.
But speech whose only harm is offending us, even greatly offending us, causing horrible emotions, that is not enough of a justification to suppress it. And the Supreme Court has rightly said, we recognize that speech that doesn't cause harm, direct punishable harm, still causes emotional and psychic harm, which is very severe and very significant and traumatic. We don't deny that. We protect speech precisely because it is so powerful. And that is power to do great harm as well as great good. But until there is direct connection to more tangible harm, we think that we have to tolerate free speech, and we have to depend on counter speech to negate those dangerous ideas.
Go ahead, Dave.
Well, I just am interested, there are different implications of free speech, right? And sometimes the press is involved as a surrogate for the public. And sometimes the press, which does not have, even though it's right there in the First Amendment, it's not as though it has more right than the public. It's just there as an example of what the rights public should have. So if you think about the past year, obviously there's been an extraordinary expression of free speech from both those peaceful protesters on January 6th, but think of BLM movement, social equity movement, those concerned about law enforcement in particular. What was interesting to me in some ways was, I wouldn't say the radicalization of the media exactly, but the factualization in some ways of the media's understanding of what happened in some of those protests. Because I talked to reporters from outfits large and small, brand names and unheard of, prize winners and novices who were caught up in the way in which the police dealt with protesters, almost all of whom were exercising First Amendment rights in a lawful way, with certainly some exceptions. But you found protesters being corralled and manhandled and at times sort of assaulted by police. You found reporters who were clearly identifying themselves as press. In fact, those who had gone to edges or corners or places along protests that they were told to go by police, who were then being beaten, hit with tear gas, being shot at with tear gas canisters, a guy being shot in the throat by a bouncing rubber bullet in Long Beach, protesters in Minneapolis, other places as well. And this is, to my mind, sort of where the rubber hits the road with free speech and with freedom of the press under the First Amendment rights. It's in the moments of tension, it's in the moments of crisis that you get to that you need to be able to exercise them most. And they need to be able, with balancing of safety and security and other issues, nonetheless need to be observed. General Tom, you want to offer us your insights here about how, in Connecticut, the Attorney General is not like the AG in Washington that oversees the equivalent of the FBI, but nonetheless, the most prominent law enforcement official for the state of Connecticut. How do you think about the way in which law enforcement needs to be observing First Amendment in times of certain degree of upheaval, both towards the press and towards those people who don't have press badges?
Yeah, I mean, every one of us who takes our law degree seriously knows that the First Amendment means that we tolerate the intolerant, and we go to great lengths to do that. And that all of what you highlighted and Nadine has highlighted, those are core to the First Amendment. And protecting speech, particularly controversial or difficult or inflammatory or odious speech in our most difficult moments, that's still our highest priority. That being said, right, you added, David, in your last discussion there, you sort of added public safety towards the end. And you
Sure.
said, like, yeah, we should make sure people are safe and observe public safety and all that. I think we can't quite be that dismissive, right?
Too cavalier.
What's that?
Too cavalier.
There are, and now we're getting in the weeds, but there are things called time, manner, place restrictions on all manner of speech when they're necessary to protect public safety. That's a really hard line to police, no pun intended, right? But there are moments, particularly when Molotov cocktails are being hurled, right? And you have, the violence in Washington, D.C. when groups of thugs visited upon the Capitol and just started tearing the place apart. We all saw that on television. The police have to do something about that because people are going to get killed. And there is a pretty clear, line that people too often cross, and that puts law enforcement in a really difficult position.
Okay, we have another question here. This is from someone who says, I'm a moderator of a private Facebook group, and which has rules in place. Do First Amendment rights matter for censoring the group?
Well, Facebook has its own community standards and terms of service, which it does say that it bases quite generally on international human rights free speech principles, which are quite similar to U.S. free speech principles. And as you probably know, Facebook recently instituted what some people call the Facebook Supreme Court, its so-called Oversight Board. It's issued 8 decisions. It just issued its 8th decision today. And that oversight board explicitly enforces the free speech guarantee under international human rights, namely Article 19 of the International Covenant on Civil and Political Rights. And so Facebook is aspiring to adhere to a larger standard that is much more similar to the First Amendment. But technically, you would only have to enforce Facebook's own community standards, which are publicly available, and examples are provided of not only the rules, but what would speech that would violate the rules.
Yeah, and this audience member also says that how much can someone question being censored, and if it clearly violates the rules that they agreed to upon joining the group?
Facebook did institute the right to appeal a couple of years ago, and in fact, it's got an appellate process internally. And what this oversight board does is, in a very small handful of cases, 8 out of the zillions, this quasi-independent board can then review a Facebook determination. But basically, it's an internal appeal process. And most of the appeals are denied.
But Nadine, if you're talking about an internal Facebook group that's being moderated, my sense is the moderator can do whatever she or he wants.
It's true. Yeah.
Facebook has First Amendment rights to set its own policies. The moderator has her or his own First Amendment rights to set policies too. We think of the First Amendment rights only applied to the person speaking, which is to a degree true. But it's also true private institutions have the right to host or not host people at their own choice. I believe.
That's absolutely right. Although I guess what you're saying is that there could be stricter rules for a particular forum that somebody is voluntarily adhering to. Absolutely.
Yeah, and people maybe say, hey, wait a second, I want to be able to say something about Bernie Sanders here. And the person can say, I'm sorry, this is about knitting, get lost. That's the person's right.
Getting back to the First Amendment, someone had asked earlier on, so can the state endorse or forbid a religion?
Nope.
It could, but it would be unconstitutional. The same core concept of viewpoint neutrality that underlies freedom of speech also underlies free exercise and non-establishment of religion. On the one hand, government may not favor religion by establishing it. On the other hand, it may not disfavor it. That would violate the free exercise clause. So the government has a delicate balance here to toe the line.
And to get a little bit over my skis, let me just say my understanding is that after the Civil War, that essentially, there was legislation that I think it's whichever amendment it is, and you know, but that basically said, look, the states and other governments can't take away the rights enumerated as federal protections without due process. And with that clause, they basically sweep in a whole bunch of things where suddenly states are like, wait, you're holding us accountable for these protections too? And the federal government said, yeah, you know what? You're not going to be able to take out away the rights of people to vote. You're not going to be able to take away their First Amendment rights either. Now, the states found ways to do that, but it was clearly unconstitutional when they did. And the fact that it had been articulated was deeply important. And you saw starting in the 1920s, when it comes to the First Amendment on non-religious terms, particularly speech, then the federal government got really serious about that in terms of, the Supreme Court got serious about that in terms of enforcing that for speech. So, this was all a process. You see principles enumerated, and then people have to figure out what it means and then figure out to whom it applies. And perhaps it should have applied to the states all along, but that might not have gotten everything ratified when it did.
And even with respect to the federal government, we had the First Amendment since 1791, and it really was honored in the breach until well into the 20th century.
Someone else asked, about the people who entered the Capitol as part of the crowd, but they didn't harm anything. Did their action constitute free speech? Is it protected?
Even if it didn't constitute free speech, if they didn't break any laws, they should not be held guilty by association. And I think that's one of the difficult factual issues here is finding specific evidence of illegal conduct by particular individuals. It's possible that everybody who was in a certain vicinity was at least committing trespass, but they certainly, if they were in a public place where they were lawfully entitled to be and did not conspire to or engage in any illegal conduct, then the fact that they were near other people who did is not enough to hold them culpable.
Okay. We have one more question coming up. Let's see. I think we've done that. It was about.
Ebon, I'm going to interrupt and ask my question personally.
Oh, okay, great.
Especially, the general manager's prerogative.
Okay, go ahead. Go right ahead.
Attorney General Tong, there has been a huge uptick across the nation on violence for the AAPI communities. What is your thinking, and what is the thinking also, David and Nadine, of our ability to better protect our communities, not just AAPI communities, historically marginalized communities where hate speech then turns into violent action? And is there a way that we could ever reverse the impact of the hate speech specifically against the AAPI community tied into the pandemic and COVID-19? Thank you.
Thank you. And sorry, I got kicked off. I hope I wasn't getting censored.
No, you weren't.
We were doing good there for a while, and the technology didn't cooperate. That's a big question, obviously, but I think a lot of what we talked about tonight is really important. Hate crimes law enforcement's important. You would expect all of that, and I can talk about all of that. But I think more importantly, we have to be responsible. And I think that includes journalists being responsible, right? And not highlighting or supercharging extreme views. I think it's this discussion we're having about social media and those platforms, and how do we prevent those platforms from being abused and used to foment hate and to organize hate, right? Which gets people hurt and gets them killed. And when you give license to people to openly hate other people, and they will, we know history tells us they will act out on it. And so that's a very difficult question, but I think a lot of what we've done tonight in talking about how to stop the flow of ideas that put people at risk while still honoring people's right to say, their honestly held beliefs, particularly their political speech. That's that's a difficult question, but I think we have to err on the side of public safety.
Okay, last week, Justice Clarence Thomas wrote an opinion in the case that had to do with former President Trump, kicking people off his Twitter feed, and the Supreme Court ruled that found that it was a moot issue because he was no longer on Twitter. But Justice Thomas wrote an opinion endorsed an opinion that would limit the ability of social media companies to moderate their content. What do you make of that? I'll start with Nadine and we'll go across.
I thought it was a really interesting opinion, and it's not the first time that Justice Thomas has used an opinion of that sort, which is really what lawyers call dicta, because it's not necessary to the decision of that particular case to raise a large issue. And here, the U.S. Supreme Court really has not grappled seriously with the huge questions that we've been addressing. And I think Justice Thomas it was very interesting and thought-provoking. As I understood, it was not necessarily endorsing any particular approach, but just saying these are really serious issues. Here are some possibilities that ought to be very seriously explored. And what's interesting is that here's Justice Thomas, who is very conservative, endorsing the consideration, at least, of certain approaches that have also been endorsed by extremely liberal experts, including University of California at Berkeley Law School Dean Erwin Chemerinsky, and a whole host of people in between. And two of the ideas are that maybe we ought to consider the big dominant platforms to be common carriers. Again, going back to points that my distinguished co-panelists have already raised, analogous to the landline telephone companies a century ago, or the railroads a century earlier, that they are such essential infrastructure for people to function in contemporary life, that they ought to be regulated public utilities. They ought to be held to a basic responsibility of fair and reasonable and non-discriminatory treatment. Another analogy that Thomas used, which was very interesting to me, because it does come out of that history of the Civil War and the post-Civil War amendments that David alluded to, is the concept of public accommodation. That this should be seen, these big platforms should be seen as basically holding themselves open to the public in general. That means they can't discriminate against particular people or particular ideas based on, who the people are or what their ideas are. And I think these are, ideas that are certainly subject to debate and criticism, but are, very serious food for thought as we grapple with the conundrum of the power that these companies have that is not directly subject to First Amendment constraints.
Okay, one last question. Rima, I believe, has one last question for you, and this is the last because we're running out of time. But Rima, I believe she had a question.
Can we? Oh, sorry.
Oh, there she is.
Go ahead. Go ahead. What did you want to do?
Oh, okay. I thought you had one last question.
No.
Okay, that speech is deliberately ambiguous, and and has ambiguous implications. How are criminal acts and lead to criminal acts? Can they still be protected? That's the last question that just came up. I'd like to take that.
I think that's a big question. And if I may, just in the last couple minutes here, I think Nadine raised some really important points. And I think my challenge with Justice Thomas and his point of view is it's just not realistic. And it doesn't live in the age that we live in, where social media can supercharge somebody's speech and get people hurt or get them killed. And going back to Rima's question about hate against Asian Americans and Pacific Islanders, you know, when the president called it the China virus and the Kung flu and blamed Asian Americans for the worst pandemic in 100 years, and certainly the worst public health crisis any of us have ever known in our lifetimes, he put a target on our backs and he made us unsafe. And now, I'll be very candid, Asian Americans and Pacific Islanders are being hunted. And speech has consequences. And I think we have to be real about that. And Twitter's not a common carrier. You know, the truckers and don't carry, you know, in most cases, violence and hateful incitement of violence to do harm to other people. And that's why that analogy doesn't work. And the problem is that people through these platforms, particularly if you have a huge megaphone like the president, can compel people to do things that can get other people hurt or get them killed. And that's a real law enforcement problem that we have to confront.
Well, we've run out of time, but we can continue the conversation at the WSHU community on your screen. And if you don't see it on your screen, the link is community.wshu.org, community.wshu.org. And thank you so much, Nadine. Thank you so much, David. And I'll finally call you William now. Thank you very much, William, Attorney General William Tong. And thanks
you,
everyone who joined us today.
Thank you.
Now I'd like to hand over to our General Manager, Rima Deal.
Good evening, everyone, and thank you again for attending this wonderful event. I'm giddy and my brain is bursting with so much thinking on some really, really insightful dialogue that we had from Nadine Strossen, NPR's David Folkenflik, and Connecticut's Attorney General William Tong. As Ebong has said, we can continue this discussion on our community platform, community.wshu.org. Thank you so very much to our sponsor for this evening, Petrosky, Reisenman, and Meyer. And thank you again to all of our WSHU listeners, donors, and sustainers. Have a wonderful evening. And all you have to do to click out of this event is to just close your browser. Have a good night.